Hello, my name is Roxette W. Stedman, BL, but my friends call me Rocksteady. Today we have a bit of a head scratcher, namely presumptions. I am only going to look at presumptions in the criminal law, but bear in mind that they occur in our civil law too. By way of definition, most people would understand a presumption in its ordinary sense as simply accepting something as fact, until that fact is disproved. And in its ordinary use, that is a pretty good definition. But as we all know, when the law gets hold of a definition, things get more complicated. In law, a presumption can be described as follows. If fact A is established, then fact B can be presumed. It is always open to a party to disprove fact B, but until they do so, fact B can be entered into evidence. Fact A is known as the basic fact, while fact B is known as the presumed fact. Presumptions are everywhere in criminal law, but they are rarely named, often misunderstood, and frequently decisive. In Irish criminal law, presumptions shape who carries the burden of proof, what a jury may infer, and sometimes what a jury must accept as fixed by law. In his authoritative work on evidence, Bograr suggests categorizing presumptions as follows: mandatory presumptions, permissive presumptions, and bare presumptions.
Mandatory presumptions are presumptions that require the tribunal of fact, upon proof of one fact, known as the basic fact, to infer the existence of another fact, known as the presumed fact. Permissive presumptions are similar in structure, except that they entitle, rather than require the tribunal of fact, to infer the existence of the presumed fact upon proof of the basic fact. Finally, bare presumptions are simply statements as to the allocation of the burden of proof, and require a conclusion to be drawn unless and until the contrary is proved.
So, if I had to define the concept, I would say that a presumption is a rule that allows, or in some cases requires, a conclusion to be drawn once a certain fact is established. Irish courts are especially careful with presumptions because they sit at the intersection of 1. Article 38 of the Constitution, which says that no person shall be tried on any criminal charge save in due course of law. This is often called the right of due process, which examines the legality of the entire process leading to a person's trial and conviction. 2. The presumption of innocence. And 3. Fair trial guarantees under the European Convention on Human Rights. Let us start by trying to understand mandatory presumptions. As stated above, these mean that where a certain basic fact is proved, then the fact finder must infer the existence of another fact, which is the presumed fact. They are often used to assist the party that bears the burden of proof. For example, as it is impossible to prove what a person was thinking or intending, a law might say that if another fact is proved, the jury can infer what that person was thinking or intending. These are often called reverse onus provisions and are controversial, as it might be argued that they offend the innocent until guilty presumption. Our courts have generally dealt with them by allowing them, but there was some disagreement as to whether they impose a legal burden on the defendant or whether the defendant bears an evidential burden only. In other words, they must provide a reasonable explanation as to why the presumed fact is incorrect. The Supreme Court answered this question in its judgment DPP versus Forsey, where O'Malley J. held that the court, in attempting to discern the impact of a particular measure on the presumption of innocence, must consider the following questions. Has the provision transferred a burden in respect of an essential element of the offense that would otherwise have fallen to be proved by the prosecution beyond reasonable doubt? Does it require the accused to prove that the element in question does not exist? Judge O'Malley said that if an accused has to prove innocent receipt on the balance of probabilities, It would mean that he or she would have to persuade the jury that it was more likely than not that he or she did not receive the money corruptly, since corrupt receipt is an essential element of the offense. It would mean that the accused would have to disprove that element. He or she would have to affirmatively prove innocence. This, she said, was a clear inroad on the presumption of innocence. If the reverse onus imposes an evidential burden only, then the prosecution must prove all the elements of the crime, and it then falls to the defendant to come up with a plausible explanation why he or she is not guilty, as opposed to having to disprove an element of the alleged crime. Let's look at one in practice. Section 15 of the Misuse of Drugs Act, 1977, tells the jury to infer that a defendant possessed a controlled drug in order to sell it as a dealer rather than possess it for personal use. If the quantity of the drug possessed is such that a reasonable person would regard it as being too much for personal use alone. The prosecution would have to prove all the elements of possession, including the amount of the drug, which would need to be considerable, one would think, before the jury are allowed to infer that the defendant was dealing. The evidential burden would then move to the defendant to explain why he or she had a large amount of the drug. For example, that he or she had a serious habit and required a large quantity for personal use. In other words, it is still open to the defendant to raise a reasonable doubt about the presumed fact. What, therefore, are permissive presumptions? As the wording suggests, these permit, rather than force, a jury to infer the existence of the presumed fact upon proof of the basic fact. Importantly, the jury can refuse to infer the existence of the presumed fact, even where the basic fact has been proven. These might be called an educated guess, as they really deal with circumstantial evidence that logically infers the presumed fact from the existence of the basic fact. Therefore, if the basic fact is conclusively proved, it is likely that a jury will draw the inference. So, for example, if evidence is led that 3 people saw a missing person in good health the day before, it is unlikely that a jury would be prepared to presume his death, but would be likely to presume continuance of life. Bare presumptions. Ironically, the most well-known presumptions are not really presumptions at all. Remember that a presumption by definition requires the proving of a basic fact before they operate. These well-known presumptions are really rules of law, which simply state that a certain condition exists until disproven. These include the well-known presumption of innocence, presumption of constitutionality, presumption of sanity, presumption of capacity of an adult. The presumption of innocence is the foundational legal presumption in Irish criminal law. Irish Supreme Court authority, including CW versus Minister for Justice, confirms that every accused is presumed innocent. The prosecution bears the legal burden of proving guilt. The standard of evidence required for a conviction is beyond reasonable doubt, and any shift of a true legal burden to the accused must be clearly provided by law and is subject to strict constitutional scrutiny. This presumption shapes how all other presumptions are assessed and limits how far the Oireachtas or the courts can go in shifting burdens onto the defense. Similarly, the presumption of sanity is one of the clearest legal presumptions in Irish criminal law. Irish courts, including in the People versus Fennell and subsequent authorities, have confirmed that the law presumes that an accused is sane and responsible for their actions. Insanity is an exception to criminal responsibility. The burden of proving insanity lies on the defense, and the standard for that burden is the balance of probabilities. This has long been accepted as compatible with the Constitution, in part because it concerns a defense rather than requiring the accused to disprove an element the prosecution must otherwise establish. Presumptions in Irish criminal law are not meant to be shortcuts to conviction. They are carefully confined rules that allocate burdens, guide juries, and operate within constitutional and convention limits. Understanding these distinctions is essential to understanding how Irish criminal trials actually work in practice. This is Rock Steady, saying take care. Until next time on The Law is My Oyster.